Retention Committee for this biennium. And we don't have introductions on the agenda, but I think that is a good place to start before speaking with everyone. So I'd like to start with a quick introductions, just names and maybe where you're from, who you represent. So,
Representative. Folks, I'm Connor Casey, and this is my district right here in Montpelier. So great to see you.
Hi, everybody. I'm Senator Ruth Hardy from the Addison District.
Brian Collmore representing the Rutland District.
Alicia Millay representing Rutland 8, Pittsford and Proctor.
Tom Oliver represents Sheldon and Swanton.
Senator Terry Williams representing Rutland County.
Eric Fitzpatrick, Legislative Council.
Thanks. And Lindsay too.
Oh, Legislative Operations, Lindsay Fryer.
Great. And I'll just wait for Senator LaRocque. If you want to introduce yourself and just who you represent.
Hi, everybody. Senator Martine LaRocque. I represent Chittenden Central.
So thank you all for being here tonight. We have as our first agenda item something called preliminary matters. And we weren't sure what that meant. And we do actually have, I believe, one preliminary matter to be raised. But I think Senator Hardy is going to raise. I'm trying to delay.
So hi, everybody. Most of you know me because I've been on this committee for a long time. And this group of judges, for those of you who are returning, was the first group of judges that I actually worked with as a member of the Judicial Retention Committee. And my recollection is that there were a couple judges from that group, and I cannot remember who they are, that had remediation letters that were part of their retention process. Again, I don't remember who it was, but if you or one of your colleagues was one of those judges, if you could provide Eric Fitzpatrick, our counsel, with that letter, that would be helpful, and we would discuss it in executive session because those letters are confidential. If it's not you, no worries, but I just wanted to put that out there because I can't remember who it was. So, thank you.
Thank you, Senator Hardy. Any questions about that or concerns about that at all? Okay. Great. So just, I guess, you all, it sounds like probably know how this tends to go. And I only know from 2 years on this committee, the last 2 years. So I'll recite from memory what I think Senator McCormick would say last year, something, I'll paraphrase. As you know, you can see we have these sizable binders of information here before us containing survey results from the surveys that were put out to attorneys, court staff, guardians ad litem, folks who work with you. And so we've reviewed those responses as well as the letters that you've provided seeking retention, as well as all of the wonderful answers you provided to the questionnaire and your court cases. So I just want to, I'm restating that for the public too. I know that you all know this, but I think it's good for anyone watching these proceedings to know what it is we're looking at and what we're going on. And then importantly, we get to actually talk to you. And that's what tonight is all about. So we will invite you up in the order that just happens to be listed on this agenda in front of me. And each of you needs to be sworn in before providing testimony. So if you'll consent to being sworn in together, we could do that now. And if I would just ask you to stand. I know you know this better than I do. Raise your right hand. And do you swear that the testimony you're about to give is the whole truth and nothing but the truth, under the pains and penalty of perjury, or so help you God?
I do.
Thank you very much. And with that, we will get started with the Honorable Dixon Corbett. Hello.
Hi.
So generally speaking, in my experience, you present us with a little something that you may have prepared. And then after that, we'll have an opportunity to go around and ask questions.
Thank you so
Sound good?
much.
Thank you.
Good evening. My name is Dixon Corbett. I'm a Vermont Superior Court judge. I'm grateful for the opportunity to speak with you tonight about my candidacy for retention. I'm new to this. I was appointed to serve as a judge less than 2 years ago. Since my appointment, I've been assigned to serve in the Civil Division of the Windsor Unit at the courthouse in Woodstock. And I'm grateful for the opportunity to serve the public by listening to my fellow citizens describe some of the hardest and most difficult problems in their life, and by helping them solve those problems by making the best decisions that I can. In the Civil Division, I'm listening every day to the struggles of those who are at risk of losing their shelter through eviction proceedings, or their homes to foreclosure, those who are facing unmanageable consumer debt. Listen to those who've been hurt in car collisions, by collapsing decks, those who've had family members killed by the wrongful acts of others. I listen to people describe the ways in which they've been stalked. I listen to citizens who are seeking public records, homeowners who are appealing their property taxes, townspeople who are seeking review of the decisions of their municipal government. I hear about election contests and recounts. I listen to incarcerated persons who are seeking review of their convictions or their furlough interruptions or the medical care they're receiving at the correctional facility. I listen to claims of consumer fraud and misrepresentation, professional malpractice, defamation, and to those who've hired someone to do contracting work at their homes and had it not work out the way they might have hoped. I'm also responsible for spending some of my time in the family division, primarily helping those who are going through divorce and parentage proceedings by making the best decisions that I can about parental rights and responsibilities and parent-child contact and property division. Each and every day, I listen to people tell me about these issues, and I have to make decisions about what will happen regarding something that's deeply important in their lives. I think that the best decisions come from having the best information. And the best information comes when everyone in the courtroom is in a position to present the best possible version of themselves. In every hearing of every day, part of my role is to put people in a position to succeed at sharing information about themselves, even when that means talking about something that's been very hurtful. I need to know what's happened and what they're hoping will happen in the future. And at the end of every day, I think back on whether I succeeded at enabling everyone to present their stories as best as they could. And at the end of every day, my conclusion is that maybe I've done some things well, but also that I've failed in some way. Always there's something I could have done better. Always there's someone who I didn't listen to enough. Always there was not enough time. Always there's more I could have done. I'm grateful for the opportunity to go through retention so early in my career. It's not often in this role that I have the opportunity for feedback from the attorneys and court staff with whom I've been interacting. Some of those attorneys I was very recently friends and colleagues with. Some of the attorneys I've never met before taking on this new role. Some of the attorneys are much older than me and have decades more experience than I in the civil division. Many of the court staff have seen many judges before me performing the same role. I'm very thankful for their feedback and grateful for the opportunity to hear it. I'm pleased that the survey results reflect many of the values that are very important to me. I value procedural fairness and empathy for litigants in difficult situations. I value the times when I talk with self-represented litigants and ask them to explain in their own words what's happening, what information they'd like for me to know about their situation, and whether they understand what decisions are being made and why. I value the opportunity to speak with the incarcerated individuals at Southern State Correctional Facility and to hear from them and let them know that someone's listening. I value trying to explain myself in written decisions and to let people know what I'm thinking and why. I value the opportunities to work with court staff and my colleagues and to pitch in and help out when I can. I'm also pleased about what's not in the survey results. A person can't be the best version of themselves if they're worried about whether attorneys will be allowed to be mean to each other in the courtroom or bully each other, whether other abusive behavior will occur. A person also can't be the best version of themselves if they're worried about whether hearings will be procedurally unpredictable and unfair. I'm glad that no one seems to feel that these sorts of things are occurring. And I'm very thankful for the constructive criticism as well. One of the hardest parts of being a judge is moderating the conversations that take place in the courtroom every day, making decisions about whose turn it is to speak, whether there should be any limitations imposed on how long they might speak or upon the content of what they might say. It would be much easier to set limitations like that ahead of time so that everyone will know what to expect, but much of what happens in a courtroom is reactionary. Perhaps an objection has been made. Perhaps someone's using more of the available time than is fair under the circumstances. Perhaps someone is describing something that's very important to them, but it's not helpful in making decisions about the issue before the court on this particular day. Making choices about whether or not to impose limits is something that happens multiple times every hearing, often in rapid succession, and there are often 8 or 12 or more hearings in any given day. And setting limits upon people's ability to speak is really hard. People are wanting to be heard about issues that are deeply personal to them. It can be very hurtful if they're not able to say all the things that they'd like to say. Ideally, I'd be able to explain to each of them individually with each and every decision, each and every time, exactly why I'm making the decisions that I'm making, but often there's simply too many decisions. There's only so much time during any given hearing to explain why a limitation is being imposed or why an objection is being sustained or overruled. I know that there are times when I don't succeed in explaining myself adequately in those moments, and I'm sorry for that. Those are the moments I think about at night. I'm grateful for the attorneys who have provided feedback about how they experience those moments. I'm hoping that I can be a better judge for them tomorrow than I was today. Before concluding my opening remarks, I would like to thank you and the legislature for your support of the judiciary, including the judges and the staff. I'm really fortunate to work with a full staff in Woodstock of excellent and experienced employees. Being funded and fully supported in this way makes it possible for each of us to be the best public servants that we can be. Thank you for your continued support. I look forward to answering any questions that you may have.
Thank you so much. So I would like for everyone to have a chance to ask a question or a follow-up if needed. So I thought what we did the last 2 years was to kind of just go around the table. I think that works well.
Sure.
Okay. Do you want to get us started?
I'd love to.
Okay.
Thank you. Overall, and for whatever reason, I found that reading, and I'll be honest, I'm not an attorney. I'm not a legal expert by any stretch of the imagination. So I tend to base my questions on what was in the surveys more than the cases that were cited. And I don't know why, but it seems like the attorneys are far more critical than the comments we receive from the staff and the non-attorneys. I don't know why. It just seems like, and that isn't just with the four of you or the four that we'll see later next week. It's, to me, always that way. And maybe there's a very good explanation. I don't know. So I'll just make that a point, and I will give it the weight that it seems to merit when I'm reading these. So we'll start, I think, Judge Corbett, with the 100% score that you received from the court staff and the non-attorneys. All the comments that were listed were positive. I didn't see one negative one. On the other hand, and again, please understand, this is not me saying it to you, but an attorney. And you had still an 8-3 positive versus negative comment, or 11 of those total. Most of them were very favorable. There were 3 that weren't. So I'll just read a couple and you can respond and I'm sure you've read them. And I struggle with the cold and robotic demeanor of Judge Corbett. He's neither kind nor unkind, respectful or disrespectful, but has a very rigid demeanor. Another one said, in over 10 years of practice, I have yet to see a judge as arrogant or concerned as Judge Corbett. He speaks to female attorneys as if they're wasting his time. And that person went on to say, I cannot recommend that this judge be retained, although if he is, sensitivity, gender bias, and legal training are required. And I'll just leave it at that and see how you respond. And again, I understand these must be tough things to read in one way. We don't go through the same process that you guys are, in essence, applying for a job. Our report cards come to us every 2 years with votes from our constituents, but rarely do we face the same sort of one-on-one situation. So I'll let it go at that.
Well, of course, it's mortifying to hear those kinds of things about yourself, right? But, okay, so here's what I think is going on. I think it goes back to what I was saying about that moderating role of the judge. And when I'm telling an attorney, right, that I'm sustaining or I'm overruling their objection, I'm telling them perhaps that they can't speak, or that I'm placing limits on when they can speak. Of course, there are dynamics with that. Of course, there are gender dynamics with that. And if an attorney doesn't understand why a judge is making the choices that they're making, the attorney, it's very, I think, very reasonable, very natural for them to think, why is the judge doing this? I don't understand. Is it that the judge doesn't like me? Is it that the judge is mad at me? Is it that the judge is biased against me or biased in some way? I think the responsibility of the judge in those moments is to explain themselves so that the attorney understands why these decisions are being made. I don't want anyone in my courtroom to feel that way. Those aren't what's in my heart. But I'm responsible if they do feel that way. And if they're thinking about these kinds of things, they can't be the best attorney that they can be under the circumstances because they're worried about what's happening. And so I don't want them to feel that way. I think my obligation is to explain myself better so that they understand what's happening and why. And as a new judge, I think that is especially important. Because with judges who've been on the bench for a long time, attorneys have a broad, rich bank of experience. If the judge has made rulings, you've seen the judge make the same kind of ruling many times before. When they say sustained or they say overruled, you know what they mean. You've seen them do it before, but as a new judge, attorneys don't have that with me. They don't know where I'm coming from. And so I think I have a heightened obligation to try to slow down and explain myself so that I know where I'm coming from, what I'm trying to do. And I'm really grateful for those comments in that sense, because they give me some feedback about how attorneys are experiencing those moments. And tomorrow when I'm out there, I'll slow down. Like, okay, here's what's happening and why. I'm wanting to listen to this point at the moment, so I'd like to hear more about that. And I hear what you're saying, and maybe we'll get to that in a little bit, but right now I want to focus on this. So that's what I hear from this.
Thank you.
Which way are we going, this way? I'm not sure, I guess I would probably just, echo what Senator Collmore has said. I'd actually taken note of those two comments as well as there was a third one that also indicated bias. So I think just being cognizant of that, as you seem to be, so. Other than that, I don't have any other specific questions.
I'll tell you what I thought about your presentation. I think it was very good. I feel a lot of thoughtfulness and desire to be articulate, fair, and sort of operating with your greatest intent. And I think maybe your visual demeanor and verbal demeanor might not be helping some people on the other side. A smile once in a while, maybe, you know. So with that, I would say it can be a bothersome job, I'm sure, taking this stuff home after, you know, doing it for a couple of years. You know, you're experiencing a lot of interesting stuff. Some of it not so good. I do deal with that.
I live with it. I go on walks in the woods. And I think about what would help. I mean, there's lots of hearings in an eviction hearing, for example. You might have an hour to spend with the parties. And in that hour, the eviction is going to occur. And maybe there's really no issue in the case. Maybe it's that the tenant, they just haven't paid their rent. They just have. And the tenant is sitting next to you. They get up and it's their turn to speak. And they don't really have anything to say about the money, but what they start talking about is their kids. They want to tell you that their kids are in 2nd and 4th grade and it's February and they're afraid if they have to move, how are the kids going to be able to stay in school for the rest of the year? If they have to move, where are they going to go? And maybe they give a personal search. That's what they want to tell you about. And that's what I'm here for. It can be very cathartic in some ways for the renter, the person to just come in and say, this is my life. And this is the moment that I'm in. Maybe there's nothing I can do to help them, but I can listen. That's something.
Thank you.
Your Honor, I have this, I read the same thing, but I also appreciated your presentation letter. And I see compassion, I see a bit of humble in your demeanor, but I also understand how you really have to, you're the standard bearer for that court. You have to set the tone because you deal with it all. I can only imagine. So I have nothing to add, but I thank you for your service.
Thank you.
Thank you very much, Your Honor. I was interested in your presentation when you were talking about a lot of incarcerated individuals come before you there, and I'm on the corrections committee, and hear from a lot of folks who are incarcerated who they feel like they don't have equal access to justice.
Mm-hmm.
And I'm wondering if do you feel that's true, and what do you do to ensure that is the case in your courtroom?
So I'm starting from a position of feeling a deep and profound responsibility for them, right? Because the government has deprived them of liberty. They're where they are because the government has put them there. So I feel a profound responsibility as part of the government to then listen to what they're saying. Are they safe? Are they being cared for? And the way that I've decided to approach it is when they file a complaint with the court, the first thing I do is I write them a letter. And I say, I've received and reviewed your petition, and I'll include a brief summary of what I see. It looks like you're complaining about, it looks like you're seeking review of the medical care that you're receiving at the facility. I'm going to schedule an initial status conference, and this is typically maybe within a week or two of getting the letter. And it'll be a chance for their attorney, if they're being represented by prisoners' rights, to also be part of the hearing, and they'll get to talk with their attorney before that. And they'll get some face time with me. And maybe it's not necessarily an opportunity for them to then say things because they're represented by the attorney. But at that hearing, they'll be able to see me and I'll be able to introduce myself and ask them their name and say you've had a chance to talk with your attorney, and we'll talk about, all right, have I read correctly? Am I understanding the issue that you're wanting review of? And we'll get that sorted out, and then we'll make a plan for how the case is going to proceed. But just that process alone is communicating to them, I've received and heard your complaint. We've talked about it, and I'm understanding what it is that you're wanting me to hear about, and we're making a plan for how we're going to work through this. And a lot of the time that gets the system working, because the attorneys for prisoners' rights are very good. And the attorneys for Department of Corrections are very thoughtful and very good. And so now, just a couple of weeks after hearing the complaint, the attorneys are talking to each other and starting to solve the problems. And a lot of them get resolved that way. And so it's sort of facilitating hearing from people and talking and getting the conversation started.
Thanks very much.
Hi, Judge. Thanks for your time tonight. I have a couple questions about the cases that you included. Terry's smiling over there. The first case, is it Commissioner of Labor v. Green, I believe?
Mhm.
And I was very interested in this concept of erroneous deprivation. And you're trying, I think, in this decision to create a new procedure because you felt like the procedure that was being used for small claims courts led people to erroneous deprivation. And I thought you did a great job of laying out your case and then the procedure that you thought. And I was really impressed that you noticed this and that people were essentially denying themselves money because they were not getting enough information about the fact that they could defer or that they could deduct some of their public assistance. So at the end, you said, for these reasons, the court will typically follow the above procedures in small claims cases. And this is just, when you say the court, do you mean your court, or is this something that will be adopted by the judiciary or reviewed by the judiciary to change the procedures overall?
Great question. So in that particular sense, I'm talking about me.
Okay.
Because what I have the ability to control is, what am I going to do when I receive these answers? So a small claims debtor is saying, yes, I agree, I owe this small amount of credit, and I'm saying I can't pay it all at once, and so I'd like to pay it in installments. And I'm saying, just for me, when I get that, I'd like to know more information. I'd like for you to get information about the debtor exemptions that may be available to you. I'd like for you to look at that and then reply to me and let me know, after you read this, do you qualify for any, do you receive any of these benefits?
Right.
And, will other, I'm aware that civil oversight is aware of the issue.
Okay.
I don't know what they'll do with it. I'm not on the committee, but I'm aware that they're aware.
Will you advocate for them to do something about it? Or can?
I will and have.
Okay.
One thing I'll add to that is I wrote that decision about a year ago.
Okay.
And so I have followed that procedure now for a whole year.
And has it worked better?
What I've found is that of the people who respond, about 60 to 70% of the people are changing their answer when they get more information.
Yeah.
People are, it's right. The people who defaulted on a couple $1,000s of consumer debt and can only afford to pay $25 or $50 a month towards that, most of them are receiving benefits.
Right. That's logical. Yeah.
And when they get the information about these are what the benefits are, take a look at this. Do you qualify? Send us, fill out the form and send it back.
Mhm.
Most of them, 60-70% of them are filling out the form saying, yes, I do, and sending it back.
Okay,
So it's helping. It's
cool.
helping me make decisions, get better information about whether they're eligible for exemptions or not.
Mhm.
And that's, I think, improving the quality of those adjudications to get that extra information.
That's excellent. I love that. And I hope that you are advocating for this change overall because it's clearly an issue that's hurting by not having enough information.
It's helpful now to have that whole year of
The
kind of
data.
data, yeah.
Awesome.
Yeah.
Okay, I have another question about a different case that, sorry, gotta get more. So I know you don't have these in front of you, but this is Figueroa v. Woodstock Resort.
Mhm.
And this is specific, you said this, that Vermont statute does not explain what it means for a plaintiff to show that a defendant's protected activity caused them actual injury, quote unquote. The language mirrors the rules that some types of cases involving the constitutional right of free speech must show special damages in the form of some pecuniary loss suffered as a result of the defamation. And my question is, should it? You say, although statute doesn't. One of the things that I find fascinating about this process and that I've really loved over the last 6 years is I have learned how to write bills better because I see what you all need us to say. So this caught my eye because you're saying, oh, the statute doesn't say this. And so my question to you is, should it? Is this a change that we should make to be more explicit?
I don't know that I have a policy answer on that. I think that when I was writing that, I was trying to say, I'm in thinking about what this element means and thinking about what actual injury means. I'm not getting my answer from the statute because it doesn't say.
Mhm.
Instead, I'm drawing my answer from this existing body of case law. And because it's using the same word, I'm interpreting the statute to mean that it's referring to this body of case law.
Okay.
As to the policy position on whether is that the interpretation that the legislature would like for the statute to have or not, I think that as a judge, my answer is whatever you say is correct. In the absence of a definition, this is how I would analyze it.
Uh-huh.
If a different definition is preferable from a legislative point of view, add it, and I'll follow that definition instead.
So absent the definition, you're looking at case law to determine how to interpret it.
That's right. I'm looking, well, I'm looking at the text of the statute. I'm looking at the history of the statute, the structure, what does it mean?
Mhm,
And then I'm looking at is this a concept that's part of case law?
mhm.
And what does the case law say about what it means? And I'm drawing from those kinds of sources.
Okay, I have one more question, Madam Chair.
Go ahead.
And this is in your letter, I think, when we were asking questions about what more does the judiciary need? Sorry, I'm just trying to get to the note that I made about, and you mentioned something about courtroom security. And I noted it because as Judge Zone and Ms. Corsones know, this is something I've worked on, and it was concerning to me that you still felt like your courtroom didn't have sufficient security in order to meet at some times. And so could you say more about that?
Sure. I think what I was referring to is that in order to hold an in-person hearing, there needs to be a court officer.
Mm-hmm.
And so if a court officer isn't available because of staffing shortages,
Mm-hmm.
I can still hold a remote hearing. I can still do some of the work of the court, but I can't invite people into the courtroom to have an in-person hearing.
Mm-hmm.
And so I think what I was describing was that's a limitation on my ability to manage the work of the court.
Yeah.
Maybe if I only have some number of days a month available for in-person time, I have to think about and prioritize who do I want to invite for the available in-person time, and who do I need to say, even if you'd like in-person time, I'm sorry, I can't accommodate that right now. I need you to participate remotely. And The specific limitation was a staffing limitation.
Okay, was this in Orange County Court?
This was in Woodstock.
Woodstock, okay,
The situation is different now because there's two other divisions now sharing the building.
uh-huh.
So the situation is now different than it was at the time that I
Is
wrote
it
the
better?
letter. Yeah, because we have, the whole county is now in one building.
Okay,
And so there's more likely court officers.
okay, that's good to hear. Because this was something we worked on. I want to make sure that security issues aren't continuing and impacting your ability to hold the cases that you are to hold.
I appreciate that.
Thank you very much.
Thank you.
I appreciate the answers that you've given and also just wanted to show my gratitude for your opening remarks. I will echo what some of my colleagues said. I appreciated your humility, self-knowledge, and your willingness to self-reflect. So thank you.
Thank you.
So I have two questions. One related to something this is in your letter. You mentioned, you gave us some data about reducing the number of cases that have been pending for over the recommended time guidelines by 50%. And I understand and appreciate you saying no single policy or action is responsible for this. But it's great. And we need, more of the same. So I'm curious, as someone who serves on the Judiciary Committee and talks about the court backlog an awful lot. If there's anything else that you see as a potential, if we're missing anything, you do mention full staffing, coordination, teamwork, and attention to detail. And I know, security issues have existed in the past. Great to hear that maybe those are resolving, but is there anything else?
It's really that sort of full staffing that is the most critical. Because if all the jobs are full and we're retaining people and people are experienced and talented, everyone's performing at their highest level. It's when we're short-staffed and people are covering more than one job and people are stretched thin, then you're doing the bare minimum to get by, but you're not really making progress each and every single day.
Yeah.
And I think that's what's happened in Woodstock is that we were fully staffed. I was there. We were really giving individual attention to each and every case. What is this case? Who is involved? What do they need to reach a resolution? And what's the next step to get there? And when you can answer those questions for every single case, you're making progress.
Mm-hmm.
And you have the time to do that if you're fully staffed and everyone's clicking.
Okay. I was curious because in conversation today in our committee, I think it's Rule 48 was mentioned. Is that what?
That would be more applicable to maybe the next judge.
Okay. I was going to ask everyone. All kinds of things bubble up and then it's like, ask that at retention. Can you ask that at retention? But, if anyone wants to talk about Rule 48, it's just an open question. My second question, this really caught my eye. You mentioned, I think it was also when you were talking about the different trainings that you've attended. And there were numerous, and one of them, you mentioned artificial intelligence, and that just caught my eye as someone who's really interested in this area and frankly terrified. So I'm curious what you think about artificial intelligence, the role that AI might play in our courts.
So I don't know, is the short answer. There's a number of things where it might apply. I'm chair of the evidence committee. And so we've talked about that in the evidence committee about how is this going to impact courtrooms. And one of the obvious early answers is, well, deep fakes. And to some extent, we've always been dealing with questions about manufactured evidence and deep fakes. And so maybe that'll be a new dimension on an existing problem. But one of the other things that we talked about that I don't really know the answer to, and I don't know what depth of a problem that's going to be, is there's always been an exception. There's always been evidence admitted in courtrooms about business records. And the reason we admit business records in the courtroom is because businesses make these records every single day. They're receipts from cash registers and stuff, and businesses rely on them for other purposes. They pay taxes based on this information, they do business based on this information, and so we accept that as a proxy for reliability. The businesses are relying on this information for their own reasons. It must have some reliable value because of that. And so we tend to accept those records as evidence. What if those records are being created by AI? Do they have the same reliability as they once did when they were being created by people? Or even when they were being created by automated processes that were at least created by people? What if the processes are created by AI? Why is the AI creating those processes? What is the AI trying to show? I don't know. I don't know how that'll play out, but if I'm thinking about AI in the courtroom, that's one of the ways I'm seeing it come into and affecting the decisions that are being made.
Thank you.
Yeah.
I'm gonna give everyone one last
I'm
chance.
fine.
Hey, can I say one more thing?
Oh, go ahead.
It's really interesting to watch you from the beginning when you sat down, and obviously you were a little nervous, and maybe the music helped in the background. But you are such a new judge, 2 years. It was nice to see you relax, and to Rep. Oliver's point about, I bristle when people tell me to smile, because never tell a woman to smile, just for the people in the room, never tell her to smile. But you told the judge to smile, and I thought it was kind of funny. But you get very animated when you and I were having the interaction, and so I hope that as you become more comfortable as a judge, you can feel that more relaxed, and I think you might be the perceptions of you might be better in that courtroom.
I appreciate that, and I read some of the comments as pointing in that same direction.
Yeah. It's just take a deep breath and relax to yourself.
Thank you.
I will say, if there's one adjective I would not use, it's arrogant,
Yeah.
in your regard, so, for what it's worth.
Yeah.
Thank you so much for your time and your thoughtfulness.
Thank you.
Eric, it's the cookies.
Importantly. All right. Up next, we have Honorable Kevin Griffin.
I'm up that.
Would you like a cookie?
I guess I can't eat a cookie. No.
Maybe right when you're done. We'll leave it there just
All right.
for that moment.
Good evening. As usual, I welcome the opportunity to come and talk to you. I have now begun my 13th year on the bench. And while Judge Corbett has had the opportunity to stay on the board during his tenure on the bench, since I last met with this committee, I have resided in Chittenden, Orleans, Essex, Caledonia, Washington, and currently I've added Windsor and Rutland counties. So it's been a really, really different experience. I wanted to sort of briefly touch base on what my experience has been for the last 6 years. Briefly talk about some of the comments or the feedback on the questionnaires. Then I'm sure there's going to be questions, including me. I was in the Northeast Kingdom for 2 years during the and we all remember what that was like, but it's really difficult for me to describe what that experience was, because I was sitting in the abuse and neglect dockets and the domestic violence dockets. And despite the fact that the pandemic came, those cases did not stop coming. And initially, when the courts were initially closed and then we quickly had them open, I made the decision because when you're sitting in that rotation, you're making decisions about whether you remove children from a home or whether you grant orders to protect people who are seeking protective orders. And I just, in good conscience, could not do it remotely. I'm also not a great techie. So I decided even throughout the pandemic that I would appear in person. And even when the technology was brought into the courtrooms, those of you who have spent time in the kingdom know the connectivity issues are terrible. So the usual scenario when I was sitting during the pandemic docket is I would be presiding. The parents of the children would be physically present in courtroom because we were able to social distance because the courtroom was cavernous. And everyone else was appearing virtually. So it was a little bit odd, but we were able to continue to address those cases in a way that we were not able to do in the criminal division because of the loss of the jury trials. And so for that 2-year period during the pandemic, we continued to move those cases in a timely fashion without accumulating a backlog. And frankly, doing it that way, we kept a lot of families together that we may not have been able to keep together if we had done it otherwise. After that rotation, I was posted in Washington County for 2 years. And I was asked to sit as the presiding judge in the criminal division. My predecessor, Judge Morrissey, had done an amazing job of addressing the cases for those individuals who were incarcerated. The biggest problem in the criminal division that you may know is that once we lost the jury trial ability, it essentially brought so much of the docket to a halt because frankly, the attorneys knew there was no threat that you were actually going to get to trial. And so we were doing everything we could to try to move the cases along. Ultimately, if we were told to just place it on the trial list, we knew that that was a dead stop until we were able to resume jury trials. Judge Morrissey had done an amazing job addressing the cases where individuals were in custody at that point. And so the task for the 2 years that I was in Washington County was to try to figure out how to chip into the backlog of cases when we were still had judicial vacancies, we were missing court staff, and we were still trying to stay on top of the cases that were coming in. Docket management is one of the hardest skills a judge can learn. But at its simplest, if you're sitting in a court where you have 10 cases that are filed, and during that same time period, you've resolved 10 cases, you're at 100% and you're doing great. We were not at 100% before the pandemic. And the pandemic just exacerbated that. And then when we were coming out of the pandemic, the challenge was, how do we get everything back on track? How do we try to address the cases that keep coming in while still chipping away at the backlog at that point? And that's what I spent 2 years doing in Washington County. And I will say that both in my postings in Washington County and in Chittenden County, where I went next, we consistently were resolving more cases during each calendar month than the cases coming in. Judges, I refer to them as box scores, but every month from the court administrator's office, you know your numbers. you know the number of cases that were added, and you know the number of cases that you resolved, and every judge checks them. And we just did an incredible job working collaboratively with the bar, the court staff, in trying to get back to a situation that was slightly less than chaotic. So I was in Washington County for 2 years, and then I was moved back to Chittenden County and asked to be the presiding judge in Chittenden County in the criminal division. And we were faced with the same challenge. Sitting in Chittenden County is very different than sitting anywhere else. First of all, you're not in control of your docket. Even if I'm the presiding judge in Chittenden County, I do not control that docket. If we're fully staffed, we have 3 judges in the criminal division, 3 judges in the family division. And my responsibilities were to oversee everything that we were doing in that criminal division. Chittenden County, you have thousands of cases pending. That's not an exaggeration. And you have a huge amount of cases being filed, and you are trying to manage those cases. You are trying to get cases to trial as best you can. And in the midst of managing this entire docket, you're also trying cases. And so during my tenure, one of the most difficult cases we've had in Chittenden County in a long time was the Burgoyne trial, which I presided over, which involved the loss of 5 young people on a tragic accident on the interstate at this point. And so you're just trying to do all of this at the same time. And I'm just trying to explain what it really is like to sit as a judge in these dockets. And I think we do a good job. And I think we've done a great job in Chittenden County. What I'm really, really excited about and what I really want to talk about for the kind of remaining time here is what I'm doing now. For the first time ever, the Supreme Court has adopted a one-judge model. And so I am now sitting in our treatment courts in Windsor County, Rutland County, Chittenden County, and Washington County. I developed a passion for treatment courts because of 2 mentors, Judge McCaffrey from Rutland, who frankly was my hero, and Judge Grierson, who is retired now. The first time I ever saw Judge McCaffrey preside in a treatment court, I was hooked. His sense of compassion and dignity that he sought to find in every person in front of him was just amazing, frankly. But this has given the judiciary an opportunity to bring all of our treatment courts in line and make sure they're being run consistent with best practices, which have just been revised. So in Rutland County, and I know we have a couple of folks from Rutland County here, your treatment court there is amazing. I know there was a concern for a while about the treatment court, but the collaborative work that's being done in the Rutland Treatment Court is almost a model for the rest of the state. The Chittenden County program, which I've worked in for years, is incredible. And I really would invite all of you at various times, I know you're in the middle of the legislative session now, but come to our treatment courts. I read the same press that you folks read. And we hear about the opiate issues in the community, and the substance use issues, and the unmet mental health needs. The work that we are doing in our treatment courts is some of the very best work that we can do as a judiciary. And now that I'm going out into the community and speaking to community groups, and what's amazing to me is so many people don't understand what we're doing in treatment court. So we are working in treatment courts with those individuals who are high risk and high need. And by high risk, I mean high risk to continue their criminal behavior. And high need because they are coming to us with substance use disorders, housing issues, co-occurring mental health disorders. They have to have a clinical assessment, but so long as they are diagnosed with a substance use disorder and the prosecutor's office supports the case coming into the program, we take them in. We are working with people who, if they were not in the program, would be in the correctional facility. So these are not folks who you could just place on probation or community diversion type programs. We are really looking at those individuals that would be incarcerated, keep them out of the correctional facility. Once they come into the program, in each program that we're doing, we have a case manager. There is a clinical team as part of the treatment team. In Chittenden County, we meet weekly because of the numbers we have in the program. In the others, they're bi-weekly. We review every participant in the program. How are they doing? It is as basic as, are they showing up for their urine tests? Are they showing up for their treatment? If they are still struggling with use, what treatment adjustments do we have to do in order to see if we can get them into recovery? And then once we get them into recovery, we do everything we can to support them in recovery, because the longer we can sustain their period of recovery, the better chance we have that that particular path of recovery for that individual can be sustained. And I am telling you, we are doing amazing, amazing work. Earlier today, I sat in our Washington County treatment court. We had a double graduation today. And the two people that we graduated today came out of the correctional facility. Had they not entered and completed the program, would still be in the correctional facility. And both individuals are solidly in recovery, working. One of our graduates today is actually now working with one of the community providers in a paid position as a peer support specialist, and is going out at night on emergencies for people who have overdosed and who need that initial connection. It was almost karma when he came into court and I was dialoguing with him, and he was complaining because he got called out at 3 a.m. because of an overdose that he was going to counsel the person with. And I just looked at him and he goes, yeah, you guys get those calls all the time. And I said, yeah, we do at this point. In Windsor County, Windsor County has always had a DUI docket. What we are now doing is we have a pilot project in Windsor County where we're standing up for the first time ever a drug court in Windsor County. And it's been interesting so far because what you really find out when you begin to put these courts together is what is actually available in the community in terms of support. So in Chittenden County, I work with the Howard Center, and they are amazing in terms of the support they've given us. Washington County, I work with Washington County Mental Health and Treatment Associates. In Rutland County, it's Rutland Mental Health and Community Care Network. They're amazing. And frankly, we're working with HCRS in the Windsor County area to get them to commit to a sufficient number of resources so that we can actually run a viable treatment court. We have literally graduated dozens of people over the course of the last 2 years. And what keeps me going in this is these are folks who come in heavily using, usually unhoused, and with a history of surviving 2, 3, 4, 5, 6 overdoses, and only to be brought back and saved by Narcan. And you compare them when they come into the program when they graduate from the program. And they are healthy and they look fantastic. And they have jobs and they've reconnected with their families. One of the most moving graduations we had in our Chittenden treatment court was of a young man who was incarcerated, who was about to lose parental rights to his 3-year-old son, who came into the treatment court program, completely turned his life around, got into a period of sustained recovery. And at his graduation, the amazing woman who was taking care of his child and was a pre-adoptive placement, and this is all part of the public record, so I'm not disclosing anything, was there to celebrate the graduation. He graduated the program having regained full custody of his son. He had a safe place to live. He was living full-time, and there was not a dry eye in that courtroom when we were celebrating his graduation. And so I feel unbelievably honored that the Supreme Court and Judge Zone have trusted me to take on this rotation. I am on the road all the time. And frankly, one of the great things about this rotation has been that beyond what I'm doing in the courtroom, we've set up these advisory committees in all of the regions. So this Friday, I'm meeting with 5 separate providers in the Windsor County area. And it's really wonderful because we just called them. We just said, could we come visit? They were thrilled that a judge actually wanted to come to their offices to see what they had to do. We're meeting with 2 Turning Point centers, and it's really been great. On these advisory committees, I know our first advisory committee in Rutland, we had the mayor come, the chief of police, service providers. These are people who are trying to brainstorm. We know we have these services. We're not always good about keeping these services together. And how can we do a better job at this point? I think a couple of weeks ago, the mayor's office in Burlington, which has also been really supportive of the program, asked us to do a public presentation on what we're doing in the treatment courts. And it was just fantastic to talk to the public. As you may have read, the folks in Chittenden County are a little concerned about crime and what's happening in Burlington. And it was really, really nice to be able to meet with these people, to talk to them about all of the great things that we're trying to do to address the problems. So if I continue in this position, I think that's the plan that I'll continue to do in the courts. Briefly, let me just say on the surveys, they're always humbling. I actually first look at the support staff surveys, the non-attorney surveys, because I think they are the true unsung heroes in the court system. We all talk about how can we move these cases and these dockets, but it's the court staff that have to make it work, that have to learn the new Odyssey system, that have to figure out how to do input everything. It is enormously, enormously stressful. So I was really, really happy that at least with respect to support staff, I do great with them, and they support retention. With attorneys, it's always a little humbling because I think when you're trying to navigate these jammed and overcrowded dockets, working with attorneys can be a different experience depending on who you're working with. So after my last retention, I decided that I would be part of the VBA midpoint review, which was great. I was really curious what those results were going to be because I would have come out of the 2 years in the kingdom and the first year in Washington County, and they were really, really positive. And so I was like, okay, I think we're doing well. And I actually was pleased with the attorney results here. I know that there were some negative comments that I'm sure I'll be asked about, but I was thrilled that over 50 people responded to the surveys. There was a 98% recommendation for retention. And after I read some of the critical comments, I went back and I actually looked at the survey results. And up and down the lines, I was pleased to see that there was an absence of bias towards, regardless of the gender of the litigants, regardless of the gender of the attorneys. It was really, really, I'm glad that they respect the fact that I come to court every day fully prepared, having read every case file before I take the bench, having fully understood what's going on in the cases, and the sense that they get fair hearings. Obviously, there were some negative comments about I was arrogant. The other was essentially pushing people too hard. And to me, it's just a reminder that no matter what our agendas are in trying to run these courts and move these cases, it's important to really take a breath and to really see who's in front of us. And if what may work for one attorney may not work for another attorney. And I understand that I cannot be a particular judge for every lawyer in front of me. But it was just a reminder that you need to approach each person in front of you as best you can in the moment, frankly. And then once you're done with that case, you move on to the next case. Easier said than done when you have 112 cases on for a final pretrial. But I promise you, I do the best I can, and I will continue to work on that skill at this point. So with that, I'm sure there's questions.
Thank you so much.
Yeah, thanks so much, Your Honor. And I can say, just living in Washington County here, I found you were very highly regarded, the time you spent here, you're still spending some time.
Yes.
Just with folks I've spoken to in town, and I think the survey largely reflects that. I'm curious, because like I'm new to this, the survey's like, you like to paint a picture with it, right? And those comments do kind of paint the picture sometimes of, he's got a bit of an edge, you know, he can be a little snarky, he can be a little testy, a little short. And, you know, I think the words old school came up a couple of times. So just as somebody who's new to this committee, I'm sort of curious, like, first of all, like, do you think that's true? What do you think a judge's demeanor should be? Because we've also heard, like, you know, we don't necessarily like people showing no emotion either, right? And old school, I keep coming back to that. How do you think you've changed over the years in your demeanor in the courtroom, or has your tenor changed? Or
so first of all, it was the first time in my career I was referred to as old school. So they're reminding me that I'm probably closer to retirement than at the beginning of my career. Judicial demeanor on the bench is critical. And I do think that on a day-to-day basis, I do the very best I can. There are absolutely times that I know that I'm frustrated. And what's interesting to me with some of the criticism, it comes from the defense bar, not the prosecution bar. In fact, some of the survey results were, for the first time ever, was slightly favoring prosecution, but it wasn't really a statistical deviation. And that's where I came from. For 30 years, I was a defense attorney. I taught defense attorneys. I believe strongly in an individual's right to be represented and to be represented well. And I am sure that I have had moments when I have had an attorney in front of me who has blown through 3 separate discovery orders without taking depositions or filing motions that I make to speak in court. I have always prided myself as a judge to never appear on that bench unprepared. And I expect the same from the attorneys who appear in front of me. I don't think that was a constant theme in the feedback when I went back and I looked at that. But again, it's humbling because I have to be conscious of where they may be at, either in terms of their caseload or their level of experience, and try to take that into consideration in terms of moment to moment to moment. And I'm just telling you, it's hard. Every judge would love a docket where you have 5 cases in the morning, 5 cases in the afternoon. They don't exist. We don't have them. And we just do the best we can. Okay.
Do we, sorry, protocol question. Do we normally go around the room or not? Are we not doing that?
We do.
Okay,
We are.
okay.
We just started at a
We're
different.
starting there. Okay, gotcha. I thought we were going from the center.
Oh.
So I'm next, Madam Chair.
You
Okay.
are.
Sure.
In this
Iteration. New iteration. We're gonna change it up each time, Senator. Judge Griffin, it's nice to see you again. You were in my first rotation of judges. And I'm so glad that you took advantage of the VBA interim survey, because that was actually something that came out
Right.
of our work together 6 years ago, and in this very room, in fact. So I'm glad that judges are using that as a sort of interim way to check in. I was going to ask you about treatment court, because that's something that's also near and dear to my heart. I serve on the opioid settlement advisory committee.
I know.
And
Thank you for the
so,
money.
yes.
Training.
We are, we don't have it yet, but, and so I was going to ask you, do you feel like the training is sufficient? Because that was what we were trying to get you more, the courts, not you specifically, but the courts more money for training judges.
So and I have other ideas about the opioids.
Okay, well, maybe you and I should talk offline.
Yes. So and I've discussed with Judge Zoning, I think almost a decade ago, we devoted a significant amount of time at the Judicial College when I almost first came on the bench, where we had, I think, a full day presentation. And the problem then was nowhere near what we're dealing with now.
Right.
And so we had amazing training. We had Dr. Brooklyn come down, and we had other providers come down and do an overview and talking about medicated assisted treatment and everything else like that. Since that time, most of the judges have retired.
Yeah.
I was looking at the Vermont reports today, and this just continues to shock me, because I feel like I am learning every day how to be a better judge. And I think I am now 6th out of 30, whatever we are, in terms of experience.
Yeah.
Which is, I got to tell you, sometimes I don't feel so great about that, because a lot of colleagues have retired. And we have a lot of great new colleagues, but the majority of the bench has not had that training. And so when I saw that your committee had approved the $50,000 to do the training, we have lots of ideas.
Oh, that's great.
About how we're going to do that.
That's great. And it was a little, it was kind of borderline. Not everybody wanted to support it. So I made the case because actually of my work on this committee, because I talked to so many judges about treatment court and what you all do. So I hope that you can use that money well. And if there are other ideas that you have for how you can address the opioid crisis through the judicial system and treatment court, you should put another application in for money next year that's even more broad, because I think that there are, connecting the dots is what we need to be doing, and we often get one-off kind of things.
So you notice I'm not turning around.
Yeah, I know, I can see
Judge
behind
Zoning
you.
or this person.
Well,
Can I, say
Yeah,
something about
please
that?
do.
So, and obviously you sense my passion about treatment courts, but the issues that we address in treatment court are in all the dockets.
Yeah.
So when I was in the kingdom, sitting on the abuse and neglect docket, the same parents that were in danger of losing custody of their children had the same substance use issues,
Yeah.
had the same co-occurring issues, had horrific histories of trauma. Certainly every woman in my program, and most of the men in my program have an unbelievable trauma history at this point. And it's in all the dockets.
Yeah.
And because of the statutes and what we as judges are asked to do, in terms of even if we say remove custody of a child from the home, we have to approve case plan. And the case plans have to address the substance use and co-occurring issues. And if judges are not conversant about methadone versus Suboxone, those are great if you have an opioid use disorder, but if you have methamphetamine, it's not going to work.
Yeah.
And so we're doing some really, really interesting stuff in the Chittenden program with contingency management, which has been pretty amazing so far.
Yep.
And is unbelievably promising. And I recently was at a training in Massachusetts where there are pilot programs where they are using different forms of medication to even address the methamphetamine issue, which is promising.
Oh, that's good.
Yeah, and what most people don't understand is that the medications can just serve to sort of stabilize. But then what we dive into in the treatment courts is, okay, if we've been able to stabilize the use, to get them to not use, then all of the underlying trauma and disorders come out. And that's what we built in to address.
Yeah.
So it's with groups, it's with trauma-informed groups, it's individual counseling. We just are constantly reworking the case plan so that we can address those issues.
It might be helpful, and then I'll stop because you and I could talk a lot about this, but for you, if you're allowed to, and I don't know if you are, to come testify to the Opioid Settlement Advisory Committee about your experiences and what recommendations you might have, because I think that would be helpful for us as we're thinking more broadly about how to use those funds.
Okay, I'll ask, but I would love to do that.
That'd be
because,
great.
I'll leave it there. 'Cause
Yeah,
I do
thank
have ideas. But,
My question was regarding your demeanor toward attorneys. It's been asked, it's been answered. My only other comment is I appreciate your passion and enthusiasm for your work, obviously, and I will go visit the treatment court. So thank you.
every Thursday, 2:30, you can come.
Awesome.
So I have a question about the Burgoyne case, and not really not really about how it was adjudicated, or even, as you mentioned, the complex legal concepts, but, I represent Williston. It happens to be, it was on the interstate in Williston where this horrible accident happened.
I remember.
And, reading this, I thought, we talk a lot about how, our judges and our judiciary system is really at the end of a long road, let's say, for a lot of folks. And when you get to a case like that, so much has gone wrong, and to end so tragically. So I was curious to hear your thoughts on what lessons could be learned using that case, about the broader system and the many failures, and maybe the need to improve. I don't know if it's communication among different services and the judiciary. And I know there are efforts underway, really great efforts regarding mental health in the courts. But I'd love to hear what you took away.
I don't know. So let me give you a couple of observations. First of all, presiding on that case was the hardest trial I've ever presided over. Not only were 5 families devastated, but the community was devastated. And that courtroom was packed. Every time we had a status conference, if it was a 15-minute status conference, it was standing room all about that. And so as a judge, you're acutely aware that you're in the spotlight the entire time. When I rotated, when I was sitting in Chittenden County at the time, we specially assigned the case to me. And we set up specific schedules to bring the attorneys in every 90 days because the case was frankly taking too long. And there's lots of ways in the case and everything else like that. But the bottom line is we were going to get that case to trial because it was pretty clear it wasn't going to settle at this point. Those families throughout the trial, I mean, it was an enormous jury selection process. Hundreds and hundreds and hundreds of jurors were summoned because of the amount of publicity in that case. Those families were unbelievable at every hearing and throughout that trial. And throughout that trial, they sat there and they listened to the evidence and they saw that. And I just, all I kept thinking, frankly, sometimes is, I don't know how they did it in terms of doing that. I don't know if that was my son or daughter. I could have done that. The jury convicted. We did the sentencing hearing. I did the best I could to articulate when I do a contested sentencing because I feel I have to own it. I outline in detail exactly what I've taken into consideration every factor on it because I wanted the families to understand what my thinking was and what I was doing and why I was structuring the sentences the way I was structuring it. What was interesting about that case, and I don't think it's inappropriate for me to say, there was a lot of early publicity about whether a medical establishment dropped the ball on it. I got to tell you, I didn't see that in the evidence. I reviewed all of, whatever that pre-UVM connection was before Mr. Burgoyne then went out and did what he did at that point. And I didn't see it. I know that there was a perception out there that mistakes had been made, but if you actually saw the videos and everything else like that, I don't think they could have done anything. So I just, that case will haunt me forever because you just can't help but sit and think if they had delayed 5 minutes, someone else may have been hurt, but that stayed with me for a while. So.
Yeah, I can imagine. Thank you.
So I had planned to go over some of the comments and the attorneys. It's obvious to me you enjoy being a judge. That was one of the comments that I was going to ask you about, but you don't need to answer that. And interestingly, the word arrogant came up again. This is the second time. I guess I'm wondering whether it might be the same person who has a predilection to use that particular adjective. So I really appreciate you bringing up the treatment court. We used to call it drug court, if I'm remembering when Judge McCaffrey began it. And you pointed out Judge Grierson, and I think your predecessor was Judge Valenti in treatment court. So all of them have done.
He still helps me.
Yeah. And for those that have not attended, thanks to Terry Torson's Judge Zone, Rutland, I'm sure they do it in the other counties too, has a court day where we're going to court. And so we attended, at least I went in, I don't know whether Senator Williams did or not, and watched treatment court. It happened to be on, I think, a Tuesday.
Yep.
And it was unbelievable. I mean, I got really emotional.
It's reaffirming.
Yeah.
It's uplifting.
Interestingly, Rutland has, I think, the only treatment court where there's a police officer assigned to be there. And sometimes it's the police chief, other times it's Officer Rosario, who has a great personality too.
Yeah.
So it's, if you haven't, I would urge the other committee members to attend treatment court. It's the best thing we do.
Your chief of police is unbelievable.
Yeah.
He comes almost every session. He quietly sits in the back. Everyone knows who he is, but he has a great relationship
Yep.
with the participants who are people that they all arrested at this point. And he has allowed us to have Officer Rosario dedicated to the team.
Yep.
So in Rutland, if someone doesn't show up at the court, Rosario goes out and finds them and brings them back in. And we try to sort of keep them in the fold. The other thing that's really beautiful about Rutland is you have the dismiss house programs down there, both for men and women, that we are utilizing. And they love us. If someone could be in our treatment court, and then we get them into dismiss house, it's just that other layer of accountability, because ultimately treatment courts work because we hold people accountable. And we celebrate their victories, but we hold them accountable for the mistakes they make in the program. And Rutland also has the ability to have the Serenity House program, the Grace House program, and now there's a new McGee program.
Yeah.
And so, so the folks in Rutland know that there's about 26 beds there that I have been telling all of my other programs that why don't we see if there's an opening in McGee? Because with the one judge model, we've been able to transfer cases. So I have 2 individuals in the Rutland program who started in Chittenden County. One of the people who graduated today in Washington County started in Chittenden County and was bombing out. He, he said today he would have been dead if he stayed in Chittenden County. But we got him into sober living in Washington County, and frankly, he's been a star. So it's really been fun. I can either sit there and say, focus on all the resources that we don't have, or I can say, let's identify the resources that we do have in the community and let's get them together and we'll do the best we can. And I'm just telling you, we're doing great work.
And I appreciate the committee's indulgence to sort of brag on my own. It really is. It's amazing.
Yeah, that's good. Yeah, I appreciate your enthusiasm, particularly with treatment court. And I imagine that with people who are going through treatment court, it's gotta be a lot of 2 steps back, maybe 1 step forward, all that. But I think that, your personality is such that I imagine it's very encouraging to people who are, going through it. Thank you.
We had an example today of someone who we just phase advanced, and she had returned to use and had tested positive for 2 of her UAs, but then got back into negative testing. She immediately notified her case manager before we even had the test results. She immediately reached out to her counselors and support. And by the time she was in front of me, she had worked it through in terms of her treatment. And she was clearly nervous about appearing today. And I just told her, this is an amazing report. I said, obviously you returned to youth, but we have a lot of work to do here. But you used the supports. I mean, 6 months ago, she wouldn't have appeared.
Right.
She would have ghosted us. She would have not appeared in court. We would have issued a warrant for her arrest. We would have had to find her and try to bring her back in. And she hung in there. And so she'll graduate.
Yeah.
She'll be great.
Great.
I'm assuming you've made the connection.
Yes.
Different outfit, right? Different outfit.
Different outfit. Yeah.
Yes.
Well,
Sure.
so I brought Stephen Burgoyne every day for his trial, as well as suffered many. I love your drug sanction. I appreciate that.
We try to do those sparingly.
So I thought, oh, this is great. I've seen this judge in the courtroom for many, 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 many hours. I don't really need much of the book. I wrote down some things. Rule 48 is not one of them. I wanted to ask, the one comment you made in here really just, it stuck out with me, about the substantial turnover court. And I've noticed that, and it's been bothering me for a lot of years. I know you have some minders in here too. And maybe we can all help each other try to solve that a little bit, but when you have that turnover that started some time ago, you lose a lot of institutional knowledge.
Absolutely.
And we lost a lot of it really quickly. And, of course, we've backfilled, but I think that's also a part of a problem with catching up. Is the efficiency that a lot of those people are. Do you have any ideas how we can get this back? Maybe just help the situation?
So first of all, in terms of the a lot of the retirements. I think it was almost like the perfect storm. First of all, the pandemic did a number on a lot of people. That was number one. Number two, that also coincided with us finally coming into the Odyssey system. And that was a huge learning curve. And some judges are better than others in terms of technology. I can tell you that I was telling Judge Corbett earlier that the last 6 years that I have served on the bench have been the hardest 6 years I've ever worked in my life. And it's supposed to be getting easier for me, but it's not, because the challenges keep coming. For a new judge coming on the bench, you can apply to be a judge, but I'm telling you, until you become a judge, you don't know what you're getting yourself into. And all of a sudden, we do the best we can to bring them on board and to train, and eventually they're sent to general jurisdiction. But frankly, after a fairly brief period of time, they're put in the docket. And they're acutely aware that they may be a brand new judge, but the litigant in front of them isn't thinking that. That's like the most important case that they have at this point. So I just think it was the perfect storm with a lot of retirements, and we help each other. We try to mentor each other. I feel a little squeamish with only 12 plus years of experience thinking that I'm a mentor to other judges, but I do mentor other judges, and especially in the area of docket management. And I will tell you that if you're really good at docket management, you're not going to be the favorite judge of some of the bar, because that's that age-old dilemma of who controls the docket. Is it the attorneys controlling the docket or the judge? I think if there's a happy medium, that's fantastic. But it's just a skill that takes time to really learn. You know, what is a legitimate request for a continuance versus there's no basis to continue.
Well, thank you. I'm glad you found the niche that you really enjoy, and hopefully you can help us out.
Well, it's kept me on the bench, I'll tell you that. I thanked Judge Sone. I wondered how this would work, given the fact that I'm listening to a lot of Audible books at this point. It just is inspiring.
So you've had some tough assignments, been on outposts, you've had some tough cases, and you worked hard to get your backlog down, in not just one county, but a lot, and that's admirable. And I appreciate your exuberance of being assigned to the drug court, because I had a neighbor kid went through that, and when he was lost her.
Yeah.
And she is a true success story. Now she's a general manager of Dollar General but she's actually a district manager now. And got two beautiful kids, and you want to be careful about enjoying your assignment too much, because they may find something for you to do that's not as desirable.
You know, whenever I'm asked to speak at public forums, what I try to remind people is that there isn't anyone in this room, even tonight, who hasn't been impacted in some way by not just the opiate crisis, but the substance use issues. And I mean, I can go on forever about the macro issues, but the bottom line is, someone once told me that if you really want to take the temperature of your community, go to your criminal court, go to your elementary schools, and go to your emergency rooms. And without exception, this is where everything is coming home to roost. And we either have to figure out how to do it better and to do it more intelligently, because we've never been able to incarcerate ourselves out of any of this. So that's where I'm at.
Thank you.
Thank you.
Thank you so much, Judge.
Thank you.
Next up, we have the Honorable Howard Kalfas. Hello.
If the music was still playing, it was
I
calming.
know. Nice.
Good evening.
Good evening.
I'd like to begin by thanking the members of the committee for your time and attention to this important task. I've been a Superior Court judge for approximately 3.5 years, and this is my first retention process. I'm glad for this opportunity to receive feedback, even that feedback that is harder for me to hear. I suspect this is usually the case, but some of the feedback came as no surprise, while other feedback frankly caught me off guard. All of it, of course, has great value, and I've already been thinking of ways to improve my practices in response. At the end of my last rotation, an attorney asked to speak with me in chambers unrelated to any case. In chamber, she asked if I had any thoughts about her performance as an attorney that I could share before I left. After sharing some observations, again about her general skills and not about any particular case, I asked her to return the favor. Much in the spirit of the surveys collected for this process, she gave me what I thought was very valuable feedback. In the 5 or 6 months since that conversation, I have made a conscious effort to adjust my practice to address her concern. I noted that her observation was also contained in one of the comments in the survey. My hope is that if she was not the attorney making the comment in the survey, the observation by the surveyed attorney was made prior to the chamber's discussion. And please be assured that the positive comments will in no way cause me to be complacent about my need for ongoing growth, development, and introspection. As members of the legislature, you all know that the law is ever evolving. This means that judges must continually study, train, and adapt. This is as true of our style and approach to the job as it is to keeping abreast of changes in the law. The retention process is an important component in this journey, and I take seriously my obligation to learn as much as I can from it. Being a judge is a privilege that I appreciate every day. I still resent the time that I have to spend before I can return to work in the morning. It sometimes seems ironic to me that the title of honorable is automatically used by many when addressing me, since I am the one who feels honored to be able to work in this capacity. And with so many wonderful people, from court staff to guardians ad litem to DCF workers to attorneys, and most importantly to litigants themselves. Compassion is often used as a measure of judges, but in reality, we are often mirroring the compassion that the people in our courtrooms demonstrate even to opponents. As general jurisdiction judges, we are expected to hear cases in every division, civil, criminal, and family. While I have covered cases in entire days or weeks in the other divisions, since my appointment in 2021, I have always been assigned to the family division. This means that I have divided my time between the juvenile and domestic dockets while also handling relief from abuse and mental health cases. Even before my appointment to the Superior Court, I was specially assigned while working as a hearing officer with Vermont Judicial Bureau to hear juvenile cases. At times, these special assignments lasted for several months while there were numerous vacancies within the judiciary. In fact, I have never held a job in the legal field that did not involve working in the juvenile docket. As a public defender, I represented children and parents in juvenile cases. As an assistant attorney general, I represented DCF in juvenile cases. During my very brief time working for a private law firm, I represented at least one parent and one grandparent in juvenile cases. Even while representing the Vermont Department of Public Safety, I was the commissioner's designee to the committee that rewrote juvenile judicial proceeding statutes in 2007. Spent more time with Eric than he probably wanted to spend at the time. Oh. Thank you for saying that. I currently have the privilege of serving as the judiciary's first statewide CHINS judge. This means that, with the rare exception of covering another docket so the judge can return to finish a CHINS case, my work is entirely devoted to the CHINS docket across the state. Most of you probably know, but CHINS is an acronym for Children in Need of Care or Supervision. It includes children believed to be abused, abandoned, neglected, unmanageable, or truant. This new position was authorized by the legislature to address the backlog in the CHINS docket around the state. Backlog can be defined and measured in many ways. For me, a backlog exists where necessary hearings cannot be scheduled for lack of hearing time. The juvenile docket has a number of hearings that are prescribed in statute. While there is always work being done behind the scenes, most progress is realized around these hearings. It is around these hearings when children are removed from parents, families are reunited, and in the worst cases, parents' rights are terminated. In 2019, I completed my master's thesis in which I studied the relationship between continuances of hearings in CHINS cases and the length of time during which children are removed from their parents' care. I found a strong correlation in that the more continuances a case saw, the more likely it is that the child remains placed out of the home, either with a friend or family member, or more likely in DCF custody. Further, the longer a child remains out of the home, the more likely it is the parent's rights will be terminated. These findings inspire the work that I do in trying to eliminate or at least minimize the backlog in the CHINS docket. To that end, I see my current position as having several distinct responsibilities. First, I keep a regularly updated spreadsheet of every pending CHINS case statewide. This tracks, among other data, when each case reaches those stages required by statute and how long children remain out of their parents' care. With this information, I work with other judges and court staff to help move cases forward. This sometimes means helping to determine which cases should take priority to make attorneys available for critical hearings in a CHINS case. Another responsibility is covering CHINS hearings throughout the state when, for an example, a judge assigned to that docket is out for any reason. Historically, courts have not scheduled juvenile cases when a judge is on vacation or will be out for some other reason. Most counties only hold juvenile hearings 1 or 2 days per week. Thus, a week away means losing a quarter of the hearing time for the month. My covering those days helps to avoid additional backlogs. The flexibility that I have also allows me to get longer and more complex hearings scheduled more quickly. For example, I recently completed an 11-day termination of parental rights hearing. Other than jury trials that are scheduled far in advance and must utilize consecutive days, such long hearings in any docket may take many, many months. Most would expect a hearing of this length to take the better part of a year, but my flexible schedule allowed us to hear it in only 4 months. When not on the bench, much of my time is spent examining all the CHINS cases pending statewide. This affords me a unique perspective and allows me to look for trends and try to come up with ways to improve the docket that might not be obvious to one looking only at their particular county. To that end, I have been working with the court administrator, the chief of trial court operations, and the chief superior judge to see what initiatives could be launched that would lead to greater efficiencies so as to get cases heard more timely while not overly burdening an already overburdened group, including court staff and attorneys. Finally, my current position and the perspective it offers lends itself to the work being done by various committees and working groups. My availability to these groups also frees up other judges who would otherwise be taking time from their dockets to attend committee meetings. I currently chair the Family Division Oversight Committee and sit on the newly resurrected Guardian ad litem Advisory Committee. I believe the legislature and judiciary took a great step forward in creating and authorizing the new statewide CHINS judge position. While I hope to continue to serve in this capacity for some time, my greater hope is that the position continues to be supported indefinitely. The juvenile docket is unique in many respects. There are timelines established by federal law that are tied to funding, and timelines established by both the Vermont legislature and the Vermont Supreme Court. More importantly, though, all children need timely permanency. These mandates are at times at odds functionally with more hearings that are required in this docket than in most others. An additional stressor is found in the fact that many of the attorneys practicing in the juvenile docket have contracts with the Defender General's office to do so in multiple counties. This makes scheduling hearings within those time standards very difficult. The judge serving in the statewide CHINS position is better poised to navigate these challenges than judges who preside over juvenile and domestic cases, and very often relief from abuse and mental health cases as well, all of which are handled by the Family Division. Of course, in 4 counties, there is but one judge for all dockets. After 15 years as a trial attorney, I was thrilled to be appointed as a hearing officer for the Vermont Judicial Bureau. 10 years later, I was honored to be appointed to the Superior Court. This is the greatest job I've had, although it does not come without stress. The backlog I discussed earlier is not unique to the juvenile docket. Incarcerated criminal defendants are waiting too long for jury trials. Separated couples are waiting too long for hearings to establish parental rights and responsibilities. Neighbors, landlords, tenants, employers, and employees are also waiting too long for jury trials. There is immense pressure to move cases forward with insufficient hearing time and in some cases, insufficient staffing, both for courts and court users, such as state's attorneys and public defender offices. Emergency after-hours work adds still more stress, both mentally and physically. While there are opportunities to collaborate toward ameliorating these stressors, I wouldn't trade this job for anything. I ask you to grant me the opportunity to continue to do this work and welcome the opportunity to answer any questions that you may have. Again, thank you for your time and attention.
Thank you so much. Would you like to start the question?
Sure, thank you, and you can pass the cookies. Thank you for being here. Thank you for your opening remarks. I really appreciate that. You had a lot of great comments here, but I will dive into something that was on my mind after reading the attorney comments, which has to do with humor, which is a very personal thing, and which can often be construed, in different ways. So I'm wondering, looking back on this episode that occurred on Halloween, if you had any, if you, looking back, if you would do something differently there, or if you learned anything from that experience.
I almost cried when I read that. So let me just start by saying that it was the most horrible thing to learn that I had caused anybody distress of any kind, or that my actions were perceived in any way as mocking anybody. This is a very stressful docket. They're all stressful. To be honest, what was going through my mind was, I've got an opportunity to make things a little happier, a little bit better. It was Halloween. I had a hearing only in the afternoon. I showed up at the courthouse mid to late morning, kind of scoped it out, made sure there were no litigants around, went in the public entrance, had a brief conversation with the court security, and went up to the clerk's office, and then ultimately went into the courtroom after ensuring that the only folks there were didn't include litigants. I, of course, in no way meant to offend anybody, nor to mock anybody. Not that this makes a difference, but I was kind of going for a Wayne World vibe, and it's regrettable that was seen as mocking a defendant. This is in no way meant to be a criticism of the attorney who made that observation. I can see it as a very reasonable observation. A judge many, many years ago talked about there being no place for humor in the judiciary, or at least in the courtroom. I'm not sure I agree with that entirely, although certainly it has to be sensitive. Everything we do has to be sensitive, of course. So, yeah, I lost a lot of sleep over that comment, and certainly will obviously never do that again. But be much more sensitive in everything that I do, particularly when I'm doing something that is not routine.
Thank you. I really appreciate that thoughtful response.
Thank you. Where are we going?
Choose your own adventure. Senator Hardy.
Oh, okay. I appreciated that response too. I was concerned about that comment. First of all, thank you for being here and for your work as a judge. It's nice to meet you.
Likewise.
I wanted to ask, there was a comment about how you tend to make decisions from the bench and that they can often seem rushed. I also, so I wanted to ask you why you tend to make decisions from the bench. Do you feel like you make too many, or did that comment, how did you receive that comment? And also I read the decisions that you did write and submitted, and I guess I would like to understand how you approach your written decisions too. I thought they were, I didn't disagree with your conclusions, but I thought they were a little thin. your written decisions. So I guess I would like to hear a little bit more about how you approach both your decisions from the bench and then the ones you choose to put into writing.
So a lot of the work that I do is juvenile work. And a lot of the decisions are ultimately boiled down to whether children are going to stay in the home, whether they're going to be reunited, whether parents' rights are going to be terminated. And these cases are very stressful for the parents in particular. Sometimes I've got children that are in the courtroom that are looking for a decision. And I feel very strongly that if I can make a thoughtful decision right then and there, it will eliminate some of the stress. They won't have to wait for it. I also believe very strongly in being able to look a parent in the eye and saying, I am removing your child, or in the worst case, I'm terminating your rights, and these are the reasons why I'm doing that. I think they're entitled to that when I can do it. There are certainly times when, even if I'm ready to do so, they're not ready to hear that. And so I won't do it then. That's what motivates me to rule from the bench as much as I can. There's also the practical reality that if writing takes a lot longer than speaking, and even a short decision is going to take at least some days. I think I've got a pretty good track record of getting my written decisions out pretty timely, typically even for long cases, which may go to your observation that my decisions are thin. And that's something that I hadn't really considered, and I appreciate that feedback. Sometimes the decisions are just too complicated, facts are too complicated to be able to rule from the bench. Sometimes, again, the parties are not ready to hear it. Other times I need to get more information. Sometimes parties feel very strongly about wanting to provide proposed findings of fact, for example, or to brief issues. And so I'll take those. So that's what goes into the calculus in terms of ruling from the bench versus taking something under advisement and writing up later. In terms of my how robust my decisions are, I'm not really sure how to answer that. I try to be as to the point as possible. In fact, Judiciary has many court-approved forms. That is particularly true of the juvenile docket because we've got all these required hearings and these required orders. And it's a lot of check boxes. And so I make it a practice to tailor almost every order that I issue, especially when I've got time to do so, by eliminating check boxes so that people aren't confused by the alternatives that I'm not choosing. And so what is very often a 3 or 4 page order for me is 1 or 2 pages. And it has just the information I think is necessary for the litigants to understand my order and be able to follow the order. And I think that's probably what drives my writing as well, wanting to be as concise as I can and as clear as I can be, while still trying to convey why it is that I'm ruling the way that I'm ruling. I appreciate the feedback and keep that in mind when I'm writing my decisions. Frankly, and I'd have to go back and look at the writing samples that I gave you, but I was trying to give you a bit of a variety, and given the limited number of pages that we were asked to, I may have pulled shorter decisions than.
The shorter ones were fine considering the amount of time I had to read them, but and I think part of it is also that your docket is so repetitive. Like, I mean, in terms of the types of cases, they're the same kind. Each other judges have a wider variety of types of cases to pull from. So that could have been a little bit, and also you're still relatively new. So that may have been also what I was reacting to, but I appreciate that you heard that feedback. I did want to also say there was a comment that someone said about how good you are with children. And I really, really appreciated that. And it's clear that you really care a lot, and done a lot in your career to help kids in Vermont. And so just wanted to thank you for that.
Thank you. I appreciate that feedback.
Great, thanks, Your Honor. I would echo the senator there. I think it's got to be a really tough gig, what you do. The juveniles you're working with, it's got to be one of the scariest times, So seeing those comments was, that was very reassuring that you would be there for the children. I have a specific question. Given the nature of the work you do, I don't know if it's real or a perception, but I've been hearing from more people in the disability community that they feel like the Vermont justice system discriminates against parents with disabilities when it comes to custody cases. And I'm sort of interested in how much you've come across that, how you weigh sort of the rights of a parent with a disability and their rights with what's best for the children there, because I think it's a tightrope sometimes. But I'm sort of curious from where we sit too. Are we doing enough in that area?
That's a really interesting question. The purposes of the juvenile judicial proceedings are set out it's the very first statute in the 4 chapters that are in Title 33. And first and foremost, we are charged in the chain of docket with maintaining or achieving permanency as quickly as possible while keeping children safe. My approach to this docket, this approach is probably shared by all the judges in this docket, is to start with the assumption that if a child needs to be removed from the parent's care, we're going to get that child back into the parent's care as quickly as we can. And that's all about putting the services in place that are necessary. And when we've got parents with disabilities, first of all, we have to know that there's a disability, and we rely on their attorneys. Very often, DCF will make us aware of that. But we are doing our best to identify those disabilities and to figure out what services we put in place to accommodate the disability so that they are able to effectively and safely parent the child as quickly as possible. I'm not aware of many cases that I've had where there have been identified disabilities that are simply insurmountable. Certainly we've had parents who have had, for example, intellectual disabilities, and they're not able to perform even the most basic tasks, such as properly feeding or diapering a child. In some of those cases, we are all, particularly the child, is so fortunate because there are natural supports in place, grandparents, siblings, sometimes even adult children of the parents who are able to either take the child, or we've actually had them embedded in the home so that the parent is able to get the support they need despite that disability to continue to parent. There are other really tragic cases where they don't have those natural supports. And ultimately, in those cases, we're never terminating their rights right out of the gate. We're presumably approving a case plan, which is going to try to get those services in place. But sadly, there are times when the service is just never enough. I hope that answers that question.
That's helpful. Thanks very much.
You're welcome. Thank you.
Thank you. I had the same issues as Senator Hewitt and Senator Hardy, but I think we answered them quite well. So it would be easier. Thank you.
Thank you.
I also was targeting sort of the same thing. Otherwise, everything looked pretty well, unless you want to take a stab at Rule 48.
No, thank you. I know when it's best to cut bait here.
So I'm gonna take the bait. I guess there was a couple comments about reluctance to grant RFAs. Did you want to address that?
Sure. I have a sense that I know where that comment came from.
Okay.
And in the back of my mind, I'm recalling a day when I was handling relief from abuse cases, and I believe that somebody, I can't recall if it was a self-represented litigant, I don't think it was an attorney, but somebody made a comment, what point you're going to grant the RFA no matter what happens anyway. And I think I may have said something like, I don't think that's the case. I don't keep data, but I may even deny more RFAs than I grant. That comment was hard to hear because obviously somebody perceived what I was saying differently than it was intended. Maybe I was inarticulate and said it that way. I certainly don't keep stats in terms of the number of RFAs that I grant or deny. I can't remember if it was that same comment or a different comment about my approaching these requests with the presumption being that I'm going to deny it. And I'm not sure that's entirely inaccurate. You know, let me be very clear. I'm talking about those after hours ex parte requests, and I'm only hearing from one party. But when we grant these requests, we are very often saying, okay, the defendant, you need to leave the home now. And it's your problem to figure out where you're going to go. We're going to give you time to grab some belongings. We're really limiting and infringing on their rights without the opportunity at that moment to be heard. And so, yeah, I think that I come at these requests saying, okay, tell me why I should, without this person having an opportunity to be heard, take away some of their rights at this time. I certainly don't hesitate to do that when the affidavit establishes that there is indeed a risk. So again, it wasn't easy to hear that. And to the extent that I will go back into the relief from abuse docket, and I hope I will at some point, I'll certainly be mindful of being sensitive to this idea. Thank you.
So I will note that all four of you got 100% scores from the court staff and non-attorneys, for what it's worth. I think that's great. I'm just noting that. The thing that was brought up, and Senator Hardy, Gulick, and I think Senator Williams all mentioned, I was struck more by the end of that comment that had to do with your performance on Halloween or whatever we want to call that. And is I do not wish to be present or have my comments shared with Judge Kalfas. I find there is little to no value in the retention process. And I don't expect you to answer that, Judge. I found that kind of a strange comment to put at the end of a question. So I'll just note it. And I thought that the attorneys realized these were all public comments that were going to be shared. So apparently someone didn't understand that rule, I guess. So I'm done.
Okay, I noted that too. I would like to ask a question of, regarding something you wrote in your letter. Very last line, you express, share that you have a lot of thoughts, particularly around jurisdiction and the transfer of cases between the family and criminal divisions. I'd love to hear some of those thoughts.
It's really complicated, different standards, slightly different processes depending on how the case is filed. And it just seems an unnecessary obstacle. These cases are, if you don't mind, I'm gonna tell you a story, and I'm sorry, but years ago, I was a public defender and I'm representing this child, probably 12 or 13 years old. And it was our first hearing in the case, and she was the subject of a delinquency petition where she was alleged to have been fighting with a classmate of hers. And so I'm in the conference room outside of the courtroom before we went in for the first time. And I'm talking to her about the case, and she's clearly very confused. And finally she said, time out, what fight are we talking about? So much time had passed. She'd had like 3 other fights since then. And you're dealing with an adolescent brain or, a young child when we're talking about delinquencies, because those are the cases that we're talking about in terms of transfer. And the hoops that we've got to jump through, or the parties have to jump through before we can even adjudicate whether this happened, let alone before we can address the issues that caused the delinquency, which is what we deal with in the juvenile docket. We've lost so much time, and the efficacy of what we're going to do is so diminished that it's troublesome. And I think that if we can streamline that process, not to the point where we're infringing on due process rights, or we lose the ability to have that flexibility to perhaps treat a juvenile as an adult. If we can do that more quickly, without having to first figure out what process do we need to use in this case, the children are just much better served and the community better served, because we're talking about behavior that is undoubtedly affecting somebody else. Maybe it's just another household member, maybe it's a member of the community. But the sooner we can address that, the sooner, the better off we all are.
Yeah, I appreciate that. And this is an area of particular interest for the House Judiciary Committee. And I know that Judge Zone is actually chair of a working group, study group, committee, what have you, that is looking into this. And would be great to get your ideas on how we might, if you haven't had the opportunity yet to share them. Having had such rich experience, I would love to hear your ideas on a child-centered approach, because that's not what we have right now.
That's a really interesting statement you just made, that we don't have, it's not a child-centered approach right now. I like to think that it is. It's just not a very good approach, not a very effective approach. So I'm perfectly happy to have further discussions about this issue.
Great, thank you.
Thank you.
Anything
Also.
lingering? All right, thank you so much.
Thank you all for your time.
Thank you.
Thank you so much, Magistrate Alicia Humbert, for your patience and for being here. Please join us. Thank you.
Good evening, everyone.
Hi.
My name is Alicia Humbert, and I've served as the Family Division Magistrate in Washington County, Orleans County, Caledonia, and Essex County since my appointment to the bench in March of 2018, with my first retention being in March 2019. First, I'm going to tell you briefly what a magistrate does, and then I'll tell you about how I view my role as a magistrate, and then finally, I'll be happy to answer any questions that you might have. A magistrate is a judge with limited jurisdiction, like a probate judge who hears probate matters, or an environmental judge who hears environmental matters. I hear cases in the family division only. I hear cases involving parentage, child support establishment, enforcement, modification, and contempt. I hear interstate support cases, and I can issue orders for child support and juvenile cases as well. I have jurisdiction to issue temporary orders in certain cases as well. The Office of the Magistrate was created by the same legislation that created the Family Court in 1990. And since then, the magistrate's jurisdiction has expanded. In 2010, magistrate candidates for retention became subject to retention proceedings, such as the one that we're doing tonight, as opposed to being reappointed by the governor. I know hearings in my courts are very stressful for people. They're often not represented and left to navigate an unfamiliar system on their own. They're sometimes scared or angry or confused. We talk about their finances in open court, so they sometimes feel vulnerable. We talk about their children, so that sometimes they feel protective or feel sad. Knowing this, I explain to them what we'll be doing at a hearing at the very beginning, so they know what to expect. I allow them an opportunity to ask questions about the proceedings before taking testimony. I hear the cases following the roadmap that I set out for the parties, and then I circle back to see if there's anything that they wanted to say and give them opportunities to ask questions of me or one another. I issue decisions on the record where possible, because this gives them a chance to ask questions if they don't understand my decision. I also strive to write decisions simply and concisely. I think that every hearing is an opportunity to impact families by educating parents and demonstrating a fair process. I'm also part of various committees, have been a part of multiple trainings. I meet with court staff, and I view all of that as an integral part of my role as well. Being a part of the retention process gives me the opportunity to reflect on all of these things, my role, and whether I achieve the goals that I set for myself during the prior retention cycle. It gives an opportunity to hear feedback that I'm eager to hear. And it makes me think deeply about the gratitude I feel to be able to work in a field that I love. So I'm happy to answer any questions that you might have.
Thank you.
I'll jump in again if you like.
Go for it.
So I'll be very brief.
Yes.
You had the perfect score. 100% on both ends, the attorneys and the staff and non-attorneys. So congratulations.
Thank you.
You had no comments one way or the other from the attorneys, which I guess that's good. And the only criticism from the staff and the non-attorneys, so that's why I was interested in your manner of speaking, was that you sometimes speak too quickly, and I don't think that's true. So I could understand every word you said.
Good, thank you. As my colleagues have reflected, the days are tight, and I believe that sometimes that makes sense to me that I would fall through that. I would look, at the clock and think, oh my gosh, we only have half an hour. I better say what I need to say quickly. And in my effort, perhaps to take that time to explain, if it's rushed, I can appreciate how that would be perceived.
It's relevant to what.
I'm all done. I'm done.
Thank you.
Yes.
I just want to follow up on that particular comment because it did catch my eye. I was a language teacher for many
Yes.
years and I work with many immigrants in my community, new Americans, and it's hard not being a native English speaker, and things like idioms are so incredibly difficult, but it really does make a difference to slow down when you are delivering whatever it might be. So I just wanted to say that I did notice that comment. It did sort of catch my eye, and I know it's not easy to speak outside of our normal cadence, but
Mhm.
might just be something to be aware of. Thanks.
Go ahead. I'll finish up.
Oh, okay. I don't have any specific comments. Yeah, it looks great. You had a lot of great, responses, so. Yeah.
So I had the pleasure of doing a magistrate lap here on the floor. And I find everything in that survey remarkably similar. I don't know how you can find two magistrates that enjoy doing what they do so much in such a difficult environment and still like it. I don't know how you guys do it, really don't. There's just gotta be something there that, I don't know, it works. But I appreciate that very much. It's difficult, and keep up the good work.
Thank you very much.
I have nothing to say, but thank you for your service and impeccable responses.
Thank you.
And I'm all set as well. Thank you very much.
Wow, I feel like I should have a heart. And I actually don't, which is super rare for me. So yeah, thank you. I remember you from 6 years ago, and I remember at that time you were fairly new.
I
Like,
was
you had
a year, less than a year. Yeah.
Exactly. And you didn't have a huge record to go on at that point, and it was all kind of weird for you to even be in the judicial retention process. So it's clear to me reading your record this time that in the 6 years you've really grown into your position and that you're doing great work. And the fact that the attorneys had nothing to say about you is I think a compliment because clearly attorneys know how to be critical. Thanks for all the work you're doing and congrats on, on.
Thank you.
I have a question.
Okay.
Two quick questions. One, I noticed that I wanted to ask if you redacted or blacked out the names in the
I did.
opinions that you shared.
I did.
I really appreciated that. We don't see that all the time where minors are involved.
I knew that it was public and I.
Right.
thought.
Yeah, so I noted that and really appreciated that thoughtfulness. I understand that as a magistrate, you work a lot with pro se litigants. And so I'm just curious if you have any thoughts about how the judiciary might better serve pro se litigants. I've observed a few during the court days that you were talking about in Chittenden County, and I've just been really impressed by the way that some judges come up as close as possible to the line of helping people without crossing that important line, to remain unbiased. So I'm just wondering if you have any thoughts on that.
So a few things on that. One is that with Judge Kalfas, I'm on the Family Division Oversight Committee. And one of the things that we do in that committee is review forms. So forms that parties fill out, order forms. And there's a really, I would say, really monumental push in making forms really readable and understandable for people, taking out the Latin, taking out the obscure phrasing, and sort of that language access that we were just talking about. So there's a mindfulness about that with, from the very beginning in the case. Then at the hearing time, the court has also good programs that promote accessibility. So not only do we have language access, hearing impaired access, but we also have communication support specialists that help people who might have a harder time understanding if they don't have an attorney to explain things to them and they're on their own. For some people, it is really difficult to understand the language. And that has actually been a valuable thing to me because I feel as if I've always felt that I do, as you described, coming to people, meeting them where they are and trying to speak in a way that's understandable, not use too much legal jargon, that's acronyms, that sort of thing. And I've had a few experiences with communication support specialists. Well, they'll say to me, that seemed confusing when you said that. Can you say that a different way? And so hearing that feedback from a communication support specialist has made me adjust the way that I speak to people, even when they don't have a communication support specialist, to explain things in a way that that might be more useful to folks. So I'm confident in saying that I wouldn't be the only one in the judiciary who when they're speaking to people who are pro ses, that self-represented people, that we try to be as accessible as possible.
Great, thank you so much.
No.
All right, well, I believe that brings us to adjournment. I really want to first thank you all for being here, thank the committee for thoughtful questions, and thank all of you for your participation in this really important process. Do we need a vote to adjourn? Declare it so. 7:25.